Welcome back. We're talking about controversial new laws in Israel that target Palestinians. Joining us from New York is Sarah Sadoun. She's a fellow at Human Rights Watch, focusing on the Middle East and North Africa. And with us from Jerusalem is Jeremy Selton. He's a member of the Bayit Yehudi Party, serving as a political analyst, manager, and advisor. Thanks to both of you for joining us. Jeremy, you are, as I mentioned, an Israeli political analyst. You have deep insight into how the Knesset, the Israeli parliament, works. You advise politicians there. You support this controversial law which allows for the forced feeding of hunger-striking Palestinian prisoners. It's caused a great deal of controversy.
Yes, I do.
And there's been a lot of criticism. Why do you support it?
Yeah, there has been a lot of criticism. There were previous versions on the table that definitely, I would say, brought up some serious questions, which I myself felt were very troublesome. But the final version of the bill that was passed, I believe, has the correct balance between the responsibility of the state for the prisoners in their custody and the rights of the prisoners to be able to go ahead and have their protest. The decision that was made in the final piece of legislation is that only in a situation where there is clear and present danger to the life of the prisoner or serious area of risk of permanent damage, only then, and again with the approval of both the Attorney General and the President of a district court, would they actually use it.
What about the accusation that this is tantamount to torture?
Again, the option here, because we're talking about people who are dealing with clear and present danger of saving their lives or dealing with permanent damage, if you don't go ahead and feed them, you're risking both either death or serious injury that would end up being permanent. And again, force feeding, a lot of people talk about tubes, but the legislation also says if you're able to do that through injections, through fluids, through IVs, that should be the first thing and only go to the feeding tubes at a last resort.
Sarah, are the provisions of this force feeding law the same as torture?
So they clearly violate the international prohibition on cruel, inhuman, and degrading treatment. Depending on which method is used, it could amount to torture. But I just want to respond to two things that Jeremy has said. Firstly, the notion that this is a balance between the responsibility of the state to care for the detainees is really does not hold up to scrutiny, because overriding a patient's will to inject them with food is in no way respecting the detainees, Israel's responsibility toward the detainees. And it's clear also that the motivation of the law is not so much the health of the prisoners, but rather to silence their protest. And one of the main proponents of the bill is the Minister of Public Security, whose name is Gilad Erdan, and he said in June about the bill that the prisoners are using hunger strikes in order to try to get terrorists released from prison, and that this bill would stop that. And so this is clearly the motivation of the bill.
Okay, let me give Jeremy a chance to respond to that. Jeremy, 2 points there. One, that this is torture. The other,
Sure.
that it is being done to silence the protesters.
It's not being done to silence anybody, and it's not torture. What we're trying to do here is make sure the prisoners don't die. If Sarah had her position really accepted by the Israeli government, you would have more Palestinian prisoners dying in Israeli jails. Now, I understand that there are some people who might want to see that, but the state has responsibility. There's not been a death of any forced feeding prisoners in over 20 years. The situation, like I said, is only if there's a clear and present danger to the health of the prisoner. Again, you need a president, not any judge, the president of a district court, not a regular court, a district court, along with the Attorney General, to sign off on this. And again, the prisoner can go ahead and have his day in court and explain why it is that he doesn't feel that he should be force-fed. And even when we are talking about force-feeding, the idea of first starting with IV fluids before having to go to the more harsh treatment of actual feeding tubes shows that, again, the interest here of the Israeli government is to save lives. And unfortunately, the position that Sarah is saying is one that could actually cost lives.
Sorry, Sarah, go ahead.
So just the reason that there haven't been deaths by force feeding in over 20 years is because Israel hasn't really used it in over in over 20 years. And doctors, medical professionals have said that it creates its own, force feeding creates its own danger. So I'm not sure what medical expertise you're relying on when you're, what you're saying is in opposition to the Israeli Medical Association. I want to also speak to the detainees can have their day in court, because that's a really interesting phrase to use. Now, one of the many of the hunger striking prisoners are actually protesting administrative detention, which is a procedure which allows Israel to hold detainees without them having their day in court. They cannot see the evidence against them, and they have no ability to, challenge that evidence, let alone be charged with a crime and have a trial. So this is very far from prisoners having the ability to challenge the decision. In fact, there is a provision in the law that says that Israel has to be sure that they have tried to convince the prisoner, the hunger striker, to stop his hunger strike and have failed. So it's actually, ironically, a situation where you're absolutely certain that you have no consent to perform this procedure in violation of basic medical ethics, let alone the Convention Against Torture.
Jeremy, just getting back to that point of access to court, seeking redress in court, it was a point made by our previous guest as well. One of the reasons we hear that these prisoners are going on strike, as we just heard from Sarah, is that they're protesting indefinite detention, and they've not been charged. They don't know what their future is going to be.
Right, so you do have about 300 to 400 Palestinians that are under what's called administrative detention. That is a sharp drop from over 1,000 around a decade ago. Administrative detention is something that's done up to 6 months. You can then renew it, but once again, you have to go to court. And yes, you do have your day in court if you are in administrative detention. You do have your right to a lawyer. What you do have in administrative court, which you do not have in other courts, is that the person that's being accused is not subject to information of what it is he is being accused. That's why, again, there's a 6-month limit, and that's why if you need to extend it, you have to go back. The reason why you don't go ahead and give that information to the defendant is because administrative detention is usually done in cases where national security interests are at risk if you go ahead and publicize what it is that they are actually being accused of. In many cases, administrative detention is a temporary measure until they're able to get other people within a terrorist cell, and then they end up charging those people in administrative detention, and then they end up going over to the regular side of regular court. Now, I understand people that want to go ahead and say, I want to hunger strike. That's fine, that's your right. But the state has a responsibility to make sure you don't die. And you need to understand that the state does not want to see people dying. And during the time where there was no forced feeding, you did have situations where you had prisoners that ended up being taken out of jail in a place where they shouldn't have been taken out of because of the terrible situation that happened to them. So there's a responsibility here by the state to be able to look after the people that are under their jurisdiction.
Sarah, is it your belief that these prisoners do have access to court, that they also have access to a lawyer, they also have some access to why they're being kept?
They have access to a lawyer, and they have every 6 months they have to go before a judge, but they have no ability to see the evidence against them. So the lawyer has no real ability to defend their client. So it's kind of, it's not a very effective form of protection. And it's not true that these are temporary or exceptional cases. I mean, as Jeremy said, there were at some point 1,000 prisoners under administrative detention. There have been thousands over the almost 50 years of Israeli occupation, including children. And many times they're renewed over and over and over again. The previous case of the hunger striker Khader Adnan, who just was recently released, was in administrative detention 10 times. So this is not a case where they're just, temporarily looking for more evidence, or it would be a problem for national security to reveal the evidence at that moment, and they need, they need to buy 2 weeks or so. Mohammed Alan has been sitting for 9 months without any real ability to confront the evidence against him. this is something that Israel has used on hundreds and thousands of occasions, and it's well beyond any allowance under international law.
Sarah Sadoun, Jeremy Salton, thanks to both of you for joining us.